Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, we do bring in immigration updates and we take live questions. Along with me is my business partner, Emily Neumann. Emily, what do we have today?
Well, we have a presidential election coming up in less than 3 months. And so we're going to talk about the two candidates, Trump versus Harris, which administration is likely to improve legal immigration, business immigration specifically, what changes might we see with either administration. And we'll also talk about University of Northern Virginia. This is a school, a debunked school from several years ago that is still haunting people that got caught up in that school as part of their green card process, the I-485. We are hearing from people that are getting questioned about that school in their 485 interviews for their employment-based green card, as well as getting RFEs on it. We've even come across a denial where the Immigration Service said that the person failed to maintain status while they were attending that school, and that years later caused the 485 to be denied. So we'll go through that. And then what about a war in the Middle East? How would that impact U.S. immigration policy? Can we expect any changes that are a result of these political issues and religious issues that are happening in the world today? And then lastly, PERM labor certification. Those delays continue. We continue to get consultations from people who are nearing their 6-year limit. PERM is still pending, wanting to know, how can I extend the H-1B if I don't have my I-140 approved yet? So back to Trump versus Harris. First of all, do you think either of them is actually going to do anything to improve legal immigration?
Well, they may try. I don't know who will try, what will try, but at least Trump has retreated again that he's going to increase the prevailing wage and do some modification to the H-1B. That most probably I'm thinking about is going to put restrictions on consulting companies employing people on H-1B, though. That's what I can think about what he can do. Can he make some more changes with regards to the Department of Labor to make sure that the consulting companies can't get a green card application process? We don't know yet on that one. But Trump definitely is going to try to restrict business immigration, even though in a single statement at one point of time, an isolated incident, he said that he's going to attach the green card to the people who are getting degrees in United States. But that's just, you can't take one sentence out of the entire person. But if you look into the history of Trump administration before, because he was the president for the 4-year period from 2016 to 2020, at that period of time, there was a lot of restrictions for H-1B. We have seen a number of H-1B denial, up to 25% of the H-1B denied, either because of the specialty occupation or because of the consulting companies, a right to control the job, and various other issues. He has removed premium processing for a significant amount of time. He stopped giving H1 and H4 and EAD along with the H1B when you file it together. He has increased the processing times of every application that I possibly can think about, and removed premium processing for a lot of those people so that he could restrict the people in whichever way he can. So definitely, I'm not expecting Trump administration coming into the power is going to be good for the employment-based immigration. Those people who want to pay taxes, those people who want to stay legally in the United States, those people who want to abide by every rule and regulations that are there, he's going to make it very tough for them. Now, obviously, on the statements, he says that he will make it tougher for illegal immigration. That part, we don't cover it. We don't practice that law. But when it comes to the business immigration, employment immigration, definitely he had made very tough for the people to stay, to come, and to work, and to continue working without interruptions at the job. He made it very tough. I don't think so it's going to be any different when he's going to come again into the power.
Yeah, I 100% agree with that. I mean, kind of it all started with the eliminating the deference memo. So basically, up until that point, whenever USCIS had approved an H-1B or an L-1 for an individual, if the same company was then filing an extension of that same visa, USCIS would usually defer to the prior approval and approve the extension unless they found there was some sort of gross error or misrepresentation or something like that. So most of the time extensions were successful. Trump came in, got rid of that memo, and that meant every time you file something, the officers are going to look at it with fresh eyes as if you've never filed before, regardless of whether they approved you last time. So people who had been getting extensions every 3 years all of a sudden get a random denial when nothing has changed about the job. We were seeing those kind of denials. And then we had the employer-employee relationship memo kind of going overboard that really impacted people that were working at end clients for consulting companies, getting shortened approvals. He initiated a regulation that never went anywhere, thankfully, but to eliminate the H-4 EAD. And then just the processing of everything, the whole system got gummed up. Like nothing could get done. There was no such thing as customer service. The USCIS is still trying to get back to normal, I guess. I don't know if that's ever going to happen again. But nothing good came out of the Trump administration for sure. With the Harris administration, I think that the focus is not going to be on legal immigration. I think they're trying to make things better for undocumented people that are in vulnerable populations, refugee, humanitarian issues, the southern border issues. I don't see them doing really anything to improve legal immigration, except maybe if there's a regulation in the pipeline that is supposed to help streamline the adjustment of status process for employment-based 485. Maybe that'll do something positive. Not much can be done without Congress, but I would assume she would continue with that. I don't know. What are your thoughts on Harris?
Definitely, I believe that Kamala Harris will be much better than Trump administration for the employment-based immigration. This is not a political statement, guys. It's not about which party it is. This is just about employment immigration, what we practice, what we have seen. Based on that, we are commenting on it. It's not a political statement. It's just what we see, what is good for the business immigration based on their past history. Definitely, she has voted for removing the per country limit for the employment-based immigration. She wanted every country people to be treated equally. She voted for it. Will she support wholeheartedly when she will be in as a president? I don't know. When she is in the vice president, she didn't bring that bill to the Senate. She did vote it when she was a senator, but when she is a vice president, she didn't put it that bill. I mean, she still has a chance because she will be the vice president until January of 2025. Even though the elections happen in November of 2024, the new administration will not come into power until January, if I'm not mistaken, until about 7th or 8th of 2025. So we call the session as a lame duck session between the November and January. The Congress, both houses, the House of Representatives and Senate meets and they do pass legislation. Normally, we see the bills like the ones removal of the per country limit actually getting on the floor at that period of time. We still have some proposals there, some bills there that are that wanted to remove the per country limit, and she right now holds the key because there are 50 senators from Democrats and 50 senators from the Republicans, and the tie vote is given to the vice president, which is Kamala Harris. So we'll have to see if they're going to bring it and she's going to vote it while she's the vice president. But I believe that Kamala Harris probably would be much better based on the past history as compared to Trump administration on the employment-based immigration. Emily, can they remove the per country limit without getting the Congress help, though? I know the lame duck session, there's a possibility when there are 50 senators from Democrats and 50 senators for Republicans, but it seems that things may change irrespective who is going to become the president. It looks like it may tilt more towards the Republicans. That means Republicans may control both, at least as the Senate, though. What do you feel? I mean, can the administration, even if Trump comes into picture or Harris comes into picture, do you think so they can make unilateral changes without going to the Congress?
On the per country limit, I don't think so. Unfortunately, that is something that the Constitution gave the power to Congress to pass the laws on immigration. Congress has already spoken on that. So the only way to undo what Congress already did is for Congress to change the law. There are other things I think the president could do, such as not counting family members, because that is they're counting family members based on their interpretation of the existing law passed by Congress, but that's not exactly what the law specifically says. They could just interpret it differently to stop counting the family members. They could give EADs to everyone with a pending I-140 or an approved I-140, like they're doing for spouses, undocumented spouses of U.S. citizens, and give parole for that as well. So there are, and certainly other things that could be done, but I don't think removing the per country cap is an option for that the president can do.
Let's move on to the next topic, Emily. As we know that University of Northern Virginia has been involved in not so good activity, and it was been closed for some F1 visa violation. They were not being issued. They were not being allowed to issue the F1 I-20s. Do you have any information what's going on it? Why are we updating on that, Emily?
So I think the school's had lost its accreditation way back in the early 2000s, like 2008, 2010, somewhere in that range. And it's considered a pay-to-play school, basically meaning that you pay your tuition and you basically don't have to take classes very often. It's all international students. There's no U.S. students that go there, and they're just allowing you to maintain some sort of status until you can make it into the H-1B lottery. And so it's been on the radar of USCIS since that time. And because we have people who are just now having their priority date become current and for their 485 that actually attended that school because they've been here on H-1B for so long, it is coming up at their green card interviews. The officers seem to have some sort of report that on that particular school and are asking a lot of questions of the green card applicants who attended that school, trying to figure out if they somehow violated their F1 status 10, 15 years ago, and that using that to say that they are now ineligible to adjust status, because for employment-based adjustment of status, you always have to show that you've lawfully maintained your status the whole time you were in the U.S. Otherwise, you have to consular process your green card. And you've even seen a denial on that issue, even though there were some solutions that could have been used to avoid that. What have you seen in that?
Yeah, Emily, almost all the people who have ever went to University of Northern Virginia are getting interviews for the 485 right now. They've been questioned very much. Yes, I have seen some denials where the USCIS said that since this person has violated the status because it's not a proper university and this guy did not provide the proper information to them, since this guy has violated the status, though, they did deny. However, Emily, there is a 245K section, though, according to which, though, there is a USCIS memo on the 245K section. The USCIS should only look into the status violation from the time they last entered into the United States to the time they filed the 485 application and further onwards. This incident of the University of Northern Virginia happened in 2013. The client that got 485 denied actually traveled to India, got the H-1B stamping and came back in 2018. And then he filed the 485 in 2020. They should only look into the status violation of 2018 to 2020. However, when the RFE was being responded, though, the lawyer did not incorporate that argument at all. I don't know whether the lawyer was aware of the 245K. I don't know if they don't know 245K. How did they become immigration lawyers? I don't know. But that 485 got denied, and and we are doing a motion to reopen right now. Most probably it will be reopened. But if anybody who has been to University of Northern Virginia, I want you to guys, if you can possibly take the grade sheets, anything that is showing that you have went to the university, because somehow they are telling that they got a report from Immigration and Custom Enforcement that people have never attended the university, people have never attended the university. So if you have any proof that you attended the university, did you pay the fees? If you have any evidence of those things, if you have a grade sheets, you need to take them. Now, obviously, the university doesn't exist right now. This university was opened by a gas station owner by name of, he was a gas station owner, and he decided, hey, why not make money? And he started a university, as was the vice chancellor or something like that of the university, and started owning this company, this university, and started giving day one CPTs, and I think so he made a lot of money and siphoned a lot of money. And USCIS has investigated this for visa fraud, and they did raid the university somewhere in 2011 to 2013 and took all the computers. I don't know what they did afterwards, but when my guys went for the interview, they said they have a lot of information about this university. So if you have gone to the University of Northern New Jersey, I would strongly recommend that you consult a lawyer, because you may get an interview. In the interview, they may question you how to answer the questions, what kind of documents you need to take, and what to provide at that point, and how to make an argument of the 245K. Because even if there is a status violation for you, though, if you ever have traveled after the incident until you file the 485 application, you should be saved with the 245K section, because that only allows the USCIS official to deny the application if you violated from the time you file the 485 application previous to the time when you last entered the United States. So if you entered into 2018, you file the 485 in 2020, they should only look from 2018 onwards, not before that. So if you are gone to University of Northern Virginia, I would strongly recommend you contact an immigration lawyer.
All right, PERM labor delays. A couple of people have asked, are there going to get any better on the PERM processing times? Are there any plans in order to improve things? And I can tell you, I think the answer to that is no. Although there was some discussion, I think at maybe last year's AILA conference, that they were hiring more officers to be able to adjudicate these based on information that we got as part of our lawsuits for these PERM delays. There seems to be no concern from any of the high-level officials of the Labor Department that their processing times are unreasonable. They don't feel that there's any harm to the beneficiary of the PERM, no harm to the company. They feel that there's no reason to hurry up and approve these PERM cases. So unless there's a change in administration, change in who's in charge of the Labor Department, at least of the ETA, Education Training Association of it, I don't see any likelihood of those getting better. So if someone has their PERM still pending, how can they extend their H-1B beyond the 6-year limit? What are the options for that?
So Emily, let me ask you this question. So if somebody filed a PERM in October of 2023 and their H-1B is expiring October of 2023, their H-1B is expiring in September of 2023, but their 6th year is expiring in November of 2024. Can they file the extension right now based on the PERM? Because as the rule says that if the PERM is pending for more than 1 year, you can extend the H-1B beyond 6 years by 1 year increments.
All right, so just to confirm, PERM was filed in October 2023, so not quite a year ago. The current H-1B expires September 2024 or 2023?
September 2024.
Current H-1B is expiring next month, but the 6-year limit is actually November 2024.
That's right.
So in that case, you can file the extension now because your H-1B is expiring less than 6 months from now. So you can always file up to 6 months in advance. You can file an extension to November 2024 to get to your 6-year limit. And then by the time you reach your 6-year limit, your PERM will have been pending for more than 365 days because your 6-year limit's November 2024. Your PERM was filed an entire year before in October 2023. So now you can file basically a 13-month H-1B extension. You request from September 2024, so November 2024, plus 1 year, getting you to November 2025. And all of that can be done now, even though the PERM has not yet been pending 365 days. So I think people are typically thinking that you always have to prove that you qualify for something on the day of filing. But for this specific issue, whether the PERM has been pending for 365 days, it's not based on the day you file the H-1B, it's based on the day you will reach your 6-year limit. By that point, will the PERM be pending for 365 days? And if the answer is yes, you can add an additional 1 year to your H-1B extension now, even though you're filing it early. And so other ways to make that happen, let's say kind of similar scenario, but your 6-year limit is actually up in September of 2024. So you have the PERM filed in October 2023 and your H-1B 6-year limit is September 2024. That doesn't give you the full 365 days, but say you traveled for 2 months at the beginning of 2024 outside the US. You can recapture those 2 months to file a 2-month extension of your H-1B. That now puts your 6-year limit beyond 365 days of your PERM when it was filed, which now means you can add another year to your H-1B extension. So taking strategic trips outside the US can help you buy back enough time to be able to get that extra year while you wait for the PERM process. And by the time that year is up, you should hopefully have your I-140 in place.
The last topic that we want to cover is that will the war in the Middle East, does it affect the employment-based immigration? Well, I have only 30 years, less than 30 years of experience, I would say. It's about 29 years of experience. And I've seen 2 major wars, good wars. One is in Afghanistan, where US was there for almost like 15 years or something like that. And I've also seen the war in Iran, where US was involved in. In that limited involvement of the direct US involvement of the war, though, we haven't seen any negative effect on business immigration at all. We haven't seen any negative effect on the H-1Bs. We have never seen anything on F-1. We have never seen anything negative on the green card as such. So I'm not expecting any different this time. Now, somebody asked, what if it's a third world war? Well, I haven't seen the third world war. My parents have not seen the third world war. I think so. My grandparents they were not been old enough to to observe what the world war was at that point of time. So I don't have that experience at this point of time to comment if there is a World War III, what will happen. But I can tell that if it's a limited war, what happened in Iraq in 2004 and in 2001, Afghanistan. In fact, the U.S. had been in war with 2 countries at the same time, and they were directly involved in it. We sent our army people in there. They were directly involved in it, so we didn't see any major issues at that point of time. In fact, we have seen some advantages to some of the Indian people. They were being invited to participate in a program called MANVI, where people who are on F-1 visas, who are on H-1B visas, they can directly enroll in the Army of the United States and get a U.S. citizenship, bypass the green card, bypass the H-1B, bypass everything, and get the citizenship directly. That program is called MANVI program. MANVI, and that was there until Trump administration came in, and then of course we pulled out of Iraq at that point of time. So he said we didn't needed to have this MANVI program, where there were less recruitees at that point of time. So they invited the student visa people, H-1B visa people directly. And when I say you get the citizenship directly, I mean it. Just they give you, you walk in, you sign in, you get the citizen. That's it. It's so simple. The whole thing can happen in just 2 months. I've seen that, but will that be back? I don't know about it, but I've generally not seen any negative consequences on the immigration. Anything else, Assembly, before we go to the questions?
Nope, I think we can move on to questions. First one, this is from Yahoo Me. Any update on visa stamping in the U.S.? We had the pilot program. Everyone agreed that the pilot program was great. Stamping in the U.S. is a good idea. No updates on it, though. No timeline for when that's going to be implemented or expanded. I don't know if the State Department has the capability of doing that right now. They're still struggling to just function normally with visa interviews and all of that. So it's something that they're planning on doing, but no timeline for it.
Tapan has this question. He's a licensed physical therapist with master's degree from India. He's on H4 without an EAD. What are his prospects of being employed? Does NIW, Schedule A or NIW help him get the employment authorization? Unfortunately, since you are from India, though, NIW will get you an I-140 approval, so that doesn't help you to get an EAD, employment authorization, though. You're supposed getting an I-140 approval definitely will help you to get an EAD, but you directly will not be beneficial. If you get an I-140 approval, that won't be good for you, though. The first thing you have to try to achieve is, Tapan, is that you are licensed in India, you said, but you didn't say you are licensed in the United States. You need to apply for the licensing authorities and get a licensing. Typically, licensing in Texas is very tough. But for example, Michigan is very easier compared to, you need to choose the states that will be more easier for you to get the licensing. Once you get the license, you may look into aspects. There are a lot of universities that may employ people, and they can bypass the H-1B. You know, the H-1B that you have to wait until October of 2025. You have to file in March of 2025, and there's a lottery system. But if you work for any university or nonprofit higher education institution, you can exempt it and continue working for them. That's one option is there. H-4 EAD option is the other thing that you can look into. Obviously, H-1B is another option that you can look into. But NIW or Schedule A, I-140, does not automatically get you the work permit for you to work in United States.
Question from Sairam on Facebook. Can I file an EB3 I-140 with a new employer without undergoing the PERM process because my EB2 485 is pending with USCIS? Unfortunately, no. Because it's a different company, that company has to have a PERM approval before you can file an EB3 I-140. So you do have to go through the PERM process again in order to file a new I-140 with a different company.
Wage change from Trump implementation, could that mean more salary for H-1B? Definitely, yeah. I mean, it could be, but at the same time, if the companies don't want to pay the salary and they still want to employ you, they will have to let you go. That's all. If some company wants to pay more salary right now, nothing is preventing them for them to pay more salaries. And you are at liberty to go keep marketing yourself from one company to another company to get a higher pay salary. But the problem here is that if at this point of time, according to the H-1B rules, the company has to pay the prevailing wages. That means that whatever is the prevailing wages, they have to. Trump wanted to tweak it to make it a little bit harder. Instead of prevailing wage, he may increase it to say that you have to pay X amount more than prevailing wage. If the company doesn't want to do it, and that may become a bigger problem for the companies, and they may have to let you go. You need to understand that H-1Bs are not only used by the IT companies, they're also used by universities, higher education institutions. I would say that 90% of the entire research happens in United States, and good amount of H-1Bs goes to the research organizations. they will be hampered, because IT companies probably already paying very high salaries, but these research institutes that are doing either AI research or different kinds of material sciences, physics, chemistry, and biochemistry and pharmaceutical industries, where a lot of research happens, they may not be able to afford it. IT companies may be able to afford it. Those will be significantly affected if Trump is going to increase or do some tweaks in the prevailing wage, where H-1Bs have to be paid higher than the prevailing wages.
Sarah Vannen says, can we expect the EB2, EB3 priority dates to move forward from October 2024? Yeah, there should be some forward movement. I don't think there will be much, because we're still getting through the thousands of applications that were reseeded in October 2020 and beyond. They allowed way too many downgrades to be filed for the number of visas available, so that they didn't have enough green cards to approve all of those 485. It left thousands of people waiting with a pending 485, and there's only so many they can approve every year now, because there's no spillover from the rest of the world, because they actually have a cutoff date as well. So it'll be crawling forward until we finally make it to January 2015. It could be another 5 years to get to that point.
January 25. Not January 15, 2025.
No, to get back to January 2015.
Oh, okay, I got it.
Another 5 years from now.
Yeah.
So 2029 maybe?
Yeah. This question is coming very many. A lot of people are asking that is October is going to open up, though. No, I agree with Emily that it's going to be a long time for us to cross. You're right, Emily. It is January. By the time we move to January of 2015, though, yeah, it may be 2020, anywhere between 2028 and 2030 is where we are expecting that date. So it's not going to move forward because of the number of applications already pending. Question comes from Muni. His friend got a DUI, and the person is planning to travel to India. First thing is that I want to make sure that the DUI case has been completely dismissed. What do you mean by dismissed? Typically, what happens in the DUI is that you'll be arrested, you'll be charged with a crime, and normally there'll be a probation period. People don't go to spend time in jail for a long period of time. So they go to probation period and they complete the probation. After they complete the probation, then they will have to, after completing the probation, the case will be dismissed. You need to have all those documentation. And when you apply for the visa stamping, especially within 5 years from the time you got the DUI, the consulate will send you to the consulate will send you to the medical examination. That will take extra time for you. It will take about 4 to 5 weeks extra for you. And then after the medical examination is done, then you'll get the visa stamping there in United States. If visa stamping in whichever country you go to. Please make a note that if you already have a visa stamping that's valid, let's say your visa stamping is valid until 2026, you cannot travel on that. You still have to go for visa stamping again. So that hurdle need to be there. That timing span should be there, because if in that period you lose the job, then you practically can't come back into the United States. So please make sure that you have all the available documents before you go to the consulate, and have that extra 5 weeks available cushion where you will have to go through the the medical examination. Make sure in the DS-160 form there is a question that is asked: have you ever been charged with any crime? You answer yes. Yes to that question. You give the details in the DS-160 form.
Wesley says, is there any relief for advanced parole delays? The AP renewal was filed more than a year ago and already expired 6 months ago, and AP processing times are at an abysmal 25 months. It is truly ridiculous that they think that that is a reasonable processing time. The good news is we are seeing faster processing times now. We're getting approvals from cases filed in February, March, April 2024, even though the ones that were filed a year ago are still pending. The best thing you can do is litigate, file a lawsuit for the unreasonable delay. We're usually able to get the approvals in about 60 days after that. It's definitely an added cost that should not be necessary for you to do, but if you're interested in it, you can reach out to Stephen Brown at our office, stephen@rnlawgroup.com.
Can you guys help for EB1A? Yes, we do, Ashutosh. But before you want to embark on having a consultation with our office, so what we want you to do is drop an email to us. We'll give you a video link and we'll give you 10 points. We want you to give the links why you think so that you may be eligible for any of those things. It'll become easier for consultation when you speak with us so that we can go over those links and have time to discuss with you that do they qualify, do they seem marginally qualified, do you need to make some improvements towards EB1A. If you're not qualified, we can give a path. If you do these activities, you may better fit in EB1A category. So even if somebody are marginally qualified, they should get their things evaluated and based on which then you can improve on. And sometimes people come back after 6 months to 2 years, and then they'll be eligible at that point of time to file for the EB1A.
Purvi says, when do you expect EB1 December 2022 to be current? It could be a while. I know we're at February 2022 and December 2022 is only 10 months away. So you would think maybe 10 months, but that's really not the case. We do know how many 485s are already pending in EB1 and we have their priority date. So you can calculate how many people are ahead of you already. I don't have the number handy off the top of my head, but we can look it up and calculate it. But what we don't know is how many EB1s India will actually get next year, because they're not limited to just the 7% cap, because EB1 rest of world usually doesn't use up all of their green cards. So anything left over from EB1 rest of world goes to India. So we don't know what that final number is going to be. On top of that, you have to think about all the people that are in EB2 or EB3 with priority dates between 2015 and 2022 that may now be eligible for EB1 and are cutting in line because they get to keep their old priority date and jump ahead of you. These are people that either now qualify for EB1A under extraordinary ability, or maybe they left the country for a year, worked abroad, and are coming back on EB1C. So either of those are options, and there's just no way to possibly guess what it could be. But what we do know is pre-COVID, we're kind of back to where we were then, and EB1 for India was backlogged by 5 years consistently. So it might be 2027 before we get to December 2022. I don't know, but definitely not anytime fast.
Mahesh has this question. He's working for 2 companies. One company is the main company, second company is a concurrently filed H-1B. Can he go for stamping for both the companies? Unfortunately, that provision is not there at the stamping. Unfortunately, the CBP, when you come into the United States, doesn't provide 2 I-94s at that point of time. The best approach for you is that you go and get the stamping with the primary company, come back in the United States, file a concurrent H-1B again. Every time you go outside the country and you come back in, you have to file that concurrent H-1B so that you can continue for both the companies.
Josh says, I'm an IT contractor through my employer on H-1B. My friend is a U.S. citizen, and he wants me to join his startup, but he can't pay anything right now. How can I join him while I continue to be with my current employer? Well, he's got to be able to pay something because the H-1B, you're in H-1B status. And so the only way for that to work is for you to file a concurrent H-1B to work for his company. But H-1Bs have a prevailing wage requirement. So he's got to pay the prevailing wage. Now, you could work part-time for his company. Maybe he can only afford to pay you for 4 hours a week. That can be specified on the LCA that he will pay you the hourly prevailing wage for 4 hours of work a week. And you can get an approval for a concurrent H-1B for that. You work for your regular employer for your 40 hours a week, do 4 hours on the weekend with the startup company. And then as that company grows and can pay more, you can amend your concurrent H-1B to increase your hours and increase the pay. So it is definitely doable, but they've got to be able to pay something.
Have Canada and Mexico, is the third country nationals allowed to get the stamping there? Yes, they can. they can get the stamping there. And third country nationals are allowed to get in Canada and Mexico. They're accepting it right now.
Lokesh says, if my initial H-1B was under a cap exempt status, can it be transferred to a non-cap exempt employer? No, not without going through the lottery. So if your first H-1B was cap exempt because the employer is a university or a government research organization, or they're affiliated with the university, you've not been counted in the cap yet. So you cannot change your employer to a for-profit employer. However, you can work concurrently for a for-profit employer without going through the lottery. So you can work full-time for your cap exempt employer and have your for-profit employer file an H-1B concurrent employment for part-time, 20 hours a week, even full-time, up to 40 hours per week, or a range to allow you to work for both companies at the same time without going through the lottery. But if you lose the cap exempt job, you won't be able to continue with the cap subject employer because you've not gone through the lottery.
I'm on GCEAD and H-1B status. My wife recently came on H-4, and biometric and medical is already done. Priority date is February 2013 in EB2. How can I file a GC for my wife? Since your priority date is not current right now, if I'm not mistaken, you have to wait for your priority date to become current, though. I'm assuming you are from India, and the priority date is not current. Let me check one more time to see. I don't remember the dates. Yes, it's not current in EB2 or EB3 in your case. So you have to wait, even though you got your medicals done, biometrics are done for H4. No, you can't file the 485 application for your wife. You have to wait for the priority date to become current. And I want you to maintain the H1B status. I want you to have your wife to maintain the H4 status. Otherwise, she will go out of status and will not be, it may create a problem for the green card. So please maintain the H1B status until you file the 485 application for your wife.
Priyanka says, I'm in Canada. I have an I-140 approved with a 2015 priority date that was from an L-1B that I had previously in the US. I've been out of the US since 2019. Now, as a Canadian, can I go with an H-1B cap exempt petition because of the I-140 approval? No, the I-140 approval waives the 6-year limit on H-1B time, but it does not waive the cap. Since you were previously on L1, not an H1, you've got to go through the lottery to work for a for-profit employer, and you use your approved I-140 to keep extending beyond the 6-year limit once you get into H-1B status.
AM has, his priority date is 2018 January. Shall I wait, or do you apply for EB5? You should consider EB5 right now, definitely, because it will give you employment authorization immediately, freedom to work for any different companies for you and your wife and your children. That definitely is available. But yes, you need to look into the pitfalls to see, is it like slam dunk? You just throw the $800,000 and you get the green card in 1 week? No, that's not how it works out in EB5. You may want to discuss with Stephen Brown in our office. He will discuss with you about it. And you have to choose an investment that is suitable to you, and then you should consider EB5. That's all I can tell, because for Indian nationals, 2018, unless something happens, so it's a long way. It's a long, long, long way.
Hardik says, if my 3-year H-1B term has expired and I'm on a B2, can I work immediately after my H-1B is filed, or do I have to wait for the H-1B approval? Is filing enough to start work? So if you are on B2, that means you're no longer in H-1B status. So a new company is not going to be filing an H-1B transfer. They're going to be filing an H-1B change of status from B2 back to H-1B. Because you're not in H-1B status, you're not eligible to use the job portability provision, which would normally allow you to work based on the filing of the H-1B. You have to wait for the approval of the H-1B. So they should be filing that in premium processing to allow you to start working as soon as possible.
Question is coming with regards to Trump administration EB5. Definitely, he will be in favor of EB5. Loosening or probably making it a little bit faster will be the Trump, that's what Trump administration would do for EB5. That's my expectation from him.
Vivek says, I'm on H1 and also have a pending AOS based on an EB1B I-140. If I'm laid off on H1 and switch to my AOS EAD, how do I notify USCIS of this change? And while I'm on the AOS EAD, what sort of jobs can I work? Number one, you don't notify USCIS. You don't have to do anything. As soon as you're no longer on H-1B, you're automatically in AOS and using the EAD if you work for any company. Now, what sort of jobs can you do on an AOS EAD? That's kind of a two-part answer because technically it's an unrestricted EAD. You can work anywhere, do anything, or not work at all. However, you need your 485 to continue to be supported. You are EB1B, outstanding researcher or professor, which means that you were sponsored by the company. And so you have to continue to have a job offer that's similar to the one you were sponsored for in order for the 485 to be able to continue. So although you technically can work anywhere, in order for your 485 to continue and actually get approved, your new job has to be in a same or similar occupation as the job that you were sponsored for.
Krishna Chetan has this question. Any chances of PERM processing improving next year? I don't know about that, though. It's very hard to predict. One thing I can tell you that there are so many alternatives, people forget it. If you look into the first part of our Emily statement with regards to when the labor is pending for 1 year, you can extend it by 1 year of the H-1B. So there are ways to get away while the labor is pending. So it may be important for you to understand that it's not that essential that the labor has to be an I-140 be approved in a faster. There are very many alternatives. Even when the labor is only pending for 7 months, if your H-1B is expiring after 12 months by the time the labor would be pending, you could extend the H-1B beyond 6 years though. And there are ways where you can go outside the country and come in. You can have a consultation with a lawyer. There are many alternatives, Chaitanya, if the PERM labor is pending. But please plan those things earlier. Don't go to the end. Don't come to me when you have only 4 days left on H-1B and then say, Rahul, help me out. That's a wrong time to do it. It's better to do it well in advance.
RK says, what happens if you get laid off while on your 7th year H-1B extension and the employer won't file the I-140? That's definitely a tough situation to be in, and that's where you need to look into, is there any way you can qualify for any of the self-sponsoring I-140s? Is there an argument that can be made that your work is in the national interest, so you could do an EB2 NIW? Even though that might not get you the green card in the near future if you were born in India, for example, but it would get you the ability to file an H-1B with a new employer and get 3 years without having to go through the PERM process. There's also the, I don't want to say new, but the EB2 exceptional ability, kind of the EB2 Schedule A Group 2, where they modified those requirements to make it a little easier to qualify for that. Well, no, I take that back because that's not self-sponsor, so forget I said that. EB1A would be your other option if there's any way you can qualify under that category. Those are going to be your best bets. Otherwise, you go outside the U.S. for a year, go through the lottery again, start a fresh 6 years.
Bautik Patel has this question. When do you think EB2 January 2022 will become current? Well, I can bet that it doesn't look to happen in your lifetime if the things go as it is. Now, I will be very happy to lose the bet. I'll be very happy to lose the bet. If something changes, I will lose the bet. I lose $10. That's fine with me. I'm happy that I lost $10. The other reason why I said is that, yeah, maybe in your lifetime it may happen, but this bet is only for me. It doesn't go through my family. So if I'm not alive, you can't claim the $10. Sorry to say that, but that's how the things are right now. If your priority date is January 2023, most probably, and EB2, that's what you said, Bautik, it's going to be very unlikely for that date to become current, because in the past 4 years, the priority date has moved 4 years backward. It used to be 3 years backward. It used to be 2015. Right now it's 2012. So in 4 years, it moved 3 years back. So it keeps moving back and forth, back and forth. It may take a long time for you to get the project date to become current. And then I'll be very happy to lose the $10 that I bet. But I want you to plan alternative. What do you mean by plan alternative? Well, try to plan to stay in United States, long-term and H-1B. Try to think about, if possible, you can move into EB-1A category. Try to possible EB-1A category. Try to possible if you can go outside the country and stay there for 1 year and come back into the country. You can even look into, if you want to look into EB-5 category. You can even look into an alternative of why stay in this country for so long and paying money to the immigration lawyers when until my death I'm not going to get the green card. I may as well want to move to Canada. That's fine too. I want to give you the realistic picture. That's the reason all this long commentary. And if I've spoken any bad words, don't take it, bad. It just, I want to tell that it's going to take a long time. I've expressed not so good words. That's all I can tell.
Vitali says, I got my I-140 denied because the company did not provide the tax returns or other primary evidence for ability to pay. They made the argument based on W-2s and pay statements, which was not sufficient. The company is now planning to refile with redacted tax returns. And in our experience, is that
looks
going to
hard,
be...
Emily. That looks
like
hard.
fraud?
No, redacted tax returns for I-140.
Yeah, I guess it depends on what exactly they're redacting, because there's definitely a lot of information in tax returns that immigration doesn't necessarily need to see. Number one, if the tax return is required, unless the company has more than 100 employees. If they have more than 100 employees, they can instead submit a letter from the CFO of the company. But if they do have less than 100, they do have to submit the tax returns. I've been able to redact certain parts of the tax returns, but USCIS needs to see the company name, definitely the tax ID number, and the net income, and as well as the Schedule L, Schedule K with the net current assets on it. There might be other things that could be redacted, okay, but without knowing what they're redacting, I can't really say.
Naimatullah Khan has this question. In the DS-160 security question, have you been arrested in the I-498A case in India? This is called dowry case in India. Recently, from April 1st, the section numbers have changed in India. I'm not caught up with those section numbers, but I know what you're speaking about, 498K, which recently got crashed by the High Court. Do I need to select the security question? Yes, yes. You're supposed to select it, yes, because in the DS-160, the question is asked, have you been arrested, charged, cited with any crime, though? So even though you're not been arrested, here you've been charged with a crime. That's the reason why you have to go to the High Court to get it quashed. So definitely you have to answer yes to that question. You have to provide all the details. So the good part about it is that if you provide the documentation from High Court, which even the consulate has access to those documents there, I have not seen much hurdles in the consulate for those people who have 498 case, because we know, the consulates in India well aware how this 498A case has been abused. In fact, recently there was a case in Karnataka where the lady, for the 7th marriage, each and every marriage, she filed a 498 case and settled the matter by taking the money from the ex-husband. 7th time she went to the court, and that lawyer bought out all the history of that lady and put it on, and now Supreme Court is considering to ease up the 498 case because of the abuse of the 498. And the consulates, US consulates in India are well aware of this 498 case.
Abhi says, my H-4 EAD is getting expired. Do I need to inform my employer or not? And is there any way I'll be questioned by my employer if I don't file the extension on time? Well, technically, it's not your job to inform your employer. They are required to monitor your employment authorization expiration as part of the I-9 process. So when the company hired you, they asked probably for your employment authorization document. They filled out your I-9. They listed the end date of your EAD on your I-9, and they're supposed to be monitoring that. So that about a month before your EAD expires, they should be coming to you saying, hey, we need to re-verify your I-9. Please provide proof of your continuing employment authorization. And when you don't have that proof, they have to terminate you. That's what the I-9 process is supposed to be. Now, if they forget, if they're not doing their I-9, that does not mean you can keep working after your H-4 EAD expired, because then working without authorization is also a violation for you, for your immigration status, can put your 485 in jeopardy in the future. So best not to get into that situation, and make sure that you timely file your extension, and make sure you stop working when your employment authorization ends.
Naimutala Kali is telling that he is from Karnataka too, where the incident happened. I hope you are not the victim of that case. But anyway, coming to the other question that I have here is that Dolly has this question. I'm delayed on my tax returns. Will the USCIS question in the 485 interview? They are asking the income tax returns there though. Definitely, if there is a delay though, it may question them. Normally, that is a hindrance in getting the citizenship. Definitely, you have to file income tax returns and pay all the dues. Otherwise, they don't give naturalization. But when it comes to the green card, they may not be that strict though. But if I were you though, I would recommend that if I were you though, I would recommend that you file income tax returns, pay the balance, and then go for the interview, because you don't want to take any chance in the counseling, in the interview.
Well, I think we're out of time. Thanks everyone for joining us. As always, we will be back next week answering your questions live and giving you the latest updates on immigration. Don't forget, you can set up a consultation with us or any of our attorneys at Reddy Neumann Brown by going to rnlawgroup.com. You'll be able to see all of our schedules and book that appointment online.